Well, hello everyone. Welcome to our roundtable discussion on Quebec's draft anonymization regulation. This session today is being hosted jointly by AccessPrivacy, Osler's Thought Leadership Forum, and the Canadian Anonymization Network, or as we call ourselves, CANON. CANON is a not-for-profit whose members consist of large data custodians across the private, health, and public sectors. And the stated objectives of CANON, which are set out on the website, for those of you who have not been, we encourage you to go at www.deidentify.ca. We love that URL. But those objectives are, among others, sharing and exchanging information about internationally evolving legal, policy, and technical standards on anonymization, developing a Canadian community practice on effective anonymization, and particularly germane for this session, advocacy for balanced legislative and policy standards for anonymization for two fundamental purposes. One, to reasonably protect against foreseeable privacy risks, and critically also to enable innovative and beneficial uses of data. Now, at the firm, here at Osler, our privacy team has been fielding calls about, and we've been having extensive discussions internally about the draft anonymization regulations. And we have over 700 registrants, folks that have registered for today's session. We have folks that are continuing to join as we speak. And this is reflective of the significant interest and the certain challenges raised about the draft regulations and the content of the draft regulations put forth by the Quebec government. And more broadly, it's really yet another example of the expanding and increasingly intense focus of interest amongst stakeholders in all sectors about the concept of de-identification and anonymization. Today's session is structured similarly to workshops that AccessPrivacy has run as part of governmental and regulatory authority consultations, such as the ones we did for the ICED Code of Practice on AI and the Quebec Privacy Regulatory Authority, the CAI's draft consent guidance. In essence, we're effectively running this discussion for the next an hour and a half to 2 hours as part of the Quebec government's consultation process. Structurally, we'll begin the session with a panel discussion, and we have an excellent panel consisting of members of CANON's steering group, specifically Khaled Elamam, who is a globally recognized expert in de-identification and anonymization, and the current... I'm sorry, if everyone could just go on mute, if you're... Thank you. I'll just introduce the panel again. Members of CANON steering group, specifically Khaled Elamam, a globally recognized expert in de-identification and anonymization and the current Canada Research Chair in Medical AI at the University of Ottawa, and co-founder and CEO of Replica Analytics. Pam Snively, who's the Chief Data and Trust Officer at TELUS Communications and TELUS Health. Suzanne Moran, a VP Enterprise of Conduct, Data Ethics, and the Chief Privacy Officer at Sun Life. And last but definitely not least, Karen Grohl, who's the Senior Special Counsel, Privacy and Data Innovation at TD Bank. Our session today will be recorded, and a copy will be sent to the Quebec government for their consideration as part of the consultation process, which ends on February 3rd. We're going to begin, as I mentioned, with a panel discussion, and then after the panel discussion, we're going to open up the floor for comments. We're encouraging live comments or questions, but of course, feel free to make comments in writing on the chat feature in the Zoom platform. And to do so, we encourage you to make those comments as the panel discussion is ongoing. If you wish, given that the session will be recorded, the Zoom feature will allow you to change your handle or the profile, so that your comments can be made without attribution to you or your company. So let's begin. Catherine, can you just put the document up on the screen? So what I'm going to do, just to, for the first for the purposes of level setting for the session, I'm just going to make a few comments about the anonymization provisions within the statute before we dive into the discussion with the panelists about the content of the draft regulations. So first, you'll see in section 23, the concept of anonymization is captured within that second paragraph, where by virtue of the provisions in Law 25, which amended Quebec's private sector privacy law, there's corresponding amendments to the public sector privacy law. We're going to be focusing on the private sector piece for this particular call, the provisions in that. Law 25 introduced changes, the vast majority of which came into effect this past September. One of them was these anonymization provisions, and there's the second paragraph basically sets out that information concerning a natural person is anonymized if it's reasonably foreseeable in the circumstances. That's one condition, that it is irreversibly no longer allows the person to be identified directly or indirectly. So basically, there's a contextual provision within the definition of anonymization. It has to be reasonably foreseeable in the circumstances. And we've had discussions amongst CANON, and that was reflected in comments CANON made to the federal government or INDU specifically as part of C27 on this exact point. And specifically, the second aspect of this is in the third paragraph, information is anonymized under the statute. It has to be anonymized in accordance with generally accepted best practices. Therefore, by implication, by reference, in a non-specific way, incorporating by reference the best practices that would appear in well-established instruments outside the statutory framework. And then it goes on to say, and according to the criteria and terms to determine by regulation. And if you look under, and you don't have to move the document, under section 90, the regulation basically says in section 90, for the purposes of this section, regulations may be made with respect to the criteria and terms applicable to the anonymization of personal information. And that is what is leading to the draft regulations there. So the second piece to mention, just before we move on, is that the anonymization provisions don't appear in a vacuum. The definitions are not within the other defined terms, a list of the defined terms, but rather the reference to the anonymization concept is within section 23, as you see on the screen, and specifically the destruction provisions, which provide that where the purposes for which personal information was collected or used are achieved, the person carrying on the enterprise must destroy or, and by implication as an alternative to destruction, anonymize it. And then that leads us to a phrase that really has been the subject to considerable discussion. It's anonymizing it, not in a vacuum, but it's stated to use it for serious and legitimate purposes. And worth making a couple of comments about this. So Law 25 introduced, as many folks on this call are aware, a number of provisions that were novel, distinct from many, if not any other statute globally. And while they're similar thematically, they certainly, I can speak with respect to client mandates, have been the subject and remain the subject of a lot of discussion. This is section 8.1, which is the profiling provision, section 9.1, confidentiality by default, and the prescriptiveness of some of the language in the consent provisions, etc. And these are discussion points that we continue to have in terms of operationalizing the provisions, and in particular, concepts relating to interoperability of this statutory regime with those other statutory instruments. This provision right here in that first paragraph, which says, or anonymize to use it for serious and legitimate purposes. This is novel and distinct, and we'd be interested in comments from folks on this, but to our knowledge, and we've looked at multiple other statutory regimes, there is not another privacy statute that has this qualification of the purpose for anonymizing data. This seems unique and therefore raises a number of different questions as to operationalizing it. We're going to be discussing that in the panel. And the final point, I just want to scroll down. If you just go to the penalty provisions in Section 91, it's an offense under the statute to attempt to identify a natural person using de-identified information or using anonymized information. So basically a re-identification prohibition once data has been anonymized. Penalties are potentially quite severe for a contravention of this particular statute. And notably, this is not the only statute that has this. There's a prohibition on re-identification in multiple statutory instruments. PHIPA is one example in Ontario domestically. There's different wording, but similar provisions in Singapore, under the CCPA in California, in Japan statute, etc. So this prohibition on anonymized data, but it is in effect, and this is an important point. I'm sorry, if everyone can go on mute. It is in effect a provision that is actually regulating the use of anonymized data. In other words, you can't use anonymized data for this re-identification purpose. Another point just to highlight. So let's turn now, just with that background, just wanted to level set for those of you who haven't spent time with the anonymization provisions, and also to level set for the purposes of the conversation. And let's turn to the panel. And I'd like to begin with three questions. We'll start with the first one. And I'm going to begin with Khaled. Khaled, in your view, given the statutory definition of anonymization, and Catherine, can you go back to that just so go back to Section 23, and the reference to, in particular, best practices and this concept of reasonably foreseeable in the circumstances, et cetera. It's just from a public policy perspective, number one, are regulations even necessary from a practical perspective in order for companies to engage in an effective anonymization practice? And I note this in particular in the context that the CAI, the Quebec Privacy Regulatory Authority, made a public statement that given the nuance of the anonymization process, the Commission believed that government regulation was needed to clarify the situation, and that pending indications from the government to this effect, that it was going to be extraordinarily difficult to actually anonymize data. So, Khaled, just get your perspective on this. Are in fact these regulations even required? And if they are not, actually required, what are some of the beneficial aspects of the proposed regs that you think are worth highlighting?
So I'll start with some general statements, and then I'll talk about the specifics in these regulations. So as a general statement, we've observed over many years that uncertainty is not beneficial. Uncertainty around what are acceptable anonymization practices. It either results in organizations doing nothing because they're afraid of taking steps in an uncertain regulatory environment, which means that potentially beneficial uses of data are not happening, or organizations and individuals in those organizations take big risks and big corporate risks or individual risks to put in place activities around anonymization in an uncertain regulatory environment. So uncertainty in general is not beneficial, and removing that uncertainty is desirable. The the regulations mention following generally accepted best practices, which is good because there are a lot of good practices out there. And I'll mention two. One is the recently published ISO standard 27599, which is a data identification standard that reflects good practices that have been in use for some time. And then, of course, there are the Ontario data identification guidelines as well, which have won awards. They're very well written guidelines. So those are two obvious documents describing good anonymization practices that one can refer to, an international one and the Canadian one. With respect to the regulations, they have many good things. So if we take the best the best principles from statutes and regulations around the world, some very good things in HIPAA, the U.S. HIPAA privacy rule around de-identification and PHIPAA, and if you take the union of those and map them to the Quebec regulations, there's a big overlap in the sense that there's a requirement for the person to be qualified, person who does anonymization to be qualified, which is a very good requirement. Talks about removing directly identifying variables first, so talking about pseudonymization, very good. Generally accepted practices, very good. Establish the protection and security measures, so essentially other controls to manage the risk consistent with best practices, reasonable foreseeable in the circumstances, so reasonableness criterion, no zero risk. That's really important, and it's written in there, which is fantastic. And then there's the requirement to do reanalysis over time. I think we'll come back to that later on, but that's consistent with best practices. How you define it, of course, is important. And then there are things in there that I think are not consistent with best practices, at least that exist today. One of them is one you mentioned about the purposes have to be defined a priori for which the purposes for the anonymized data. And then there are three criteria. There are correlation, inference, and individualization, which are consistent with the European Article 29 Working Party opinion on anonymization techniques, linkability, inferences, and singling out. And those are problematic because even under the context of GDPR and the implementation of these criteria, we just don't know how to do it. I mean, came out in 2014, so we're basically 10 years later. We still don't know what they mean. And we still have discussions about what these things mean and how to interpret them. Academics are writing about them. People are struggling to interpret them. So the fact that these three criteria showed up in 2024, I think increases uncertainty. And then the two.
And Colette, just to, so we're helping folks along the line. Catherine, can you just scroll down just to catch up before your next point?
Yeah.
So first of all, Colette was just mentioning here these definitions, correlation, individual inference, and Colette, we're going to get to the challenges in the second question, but I just want to highlight a couple of, in particular, points. If you go to section 7, I want to highlight the point that Colette mentioned. Go down, Catherine. To section 7. Here is this reference of the zero risk piece. And if you go down for the purposes, look at the third paragraph. For the purposes of the second paragraph here in section 7, it is not necessary to demonstrate that zero risk exists, and however, taking into account the following elements. And I think, I don't want to put words in your mouth, Colette, but I think this is what you were highlighting that was beneficial of the proposed regs. Am I correct?
Absolutely. I mean, it says irreversibly no longer allow the person to be identified. So the word irreversible kind of implies zero risk, but then the subsequently it says not zero risk. So that's good. However, if the word irreversible um, is removed, that would make it more consistent with the concept of zero risk, because generally irreversible is interpreted as zero risk. But the last two things I will say is the things that are missing are, the under the US HIPAA, we talk about you evaluate the risk from the perspective of the anticipated recipient, and there are various court cases from in the European context that have essentially reached the same conclusion, and that the same data may have different risk levels depending on who's processing the data. So really, you measure the risk from the perspective of anticipated recipient. I think this is a really important concept. So that's missing. And then another big one is consent for anonymization, which is very clear under PHIPAA, but that's not mentioned here in terms of whether you require consent for anonymization or not. So all that to say, to summarize, I know it's a long answer, but it's kind of an opening statement. So the reduction of risk is important. There are a lot of good things here, some things that I think will be harder to operationalize, some things that are missing. Having guardrails is good. There are good practices. We can just say use good practices, but if a regulation is going to be written, then they should be consistent with good practices. And so all the points I raised are trying to make it consistent with those good practices.
Right. And so just to even further give a summary of your summary at the end, what you're saying is just with the definition of anonymization, which expressly contemplates best practices, while it might not be critical, like for the purposes of the operationalization and the organizations engaging in the anonymization practice, there's beneficial aspects, especially let's go back to number 7 of this reg, because of that statement that it doesn't have to be zero risk, which is very important. And there seems to be other aspects of this draft regulation that overlap with well-established standards or other principles for effective de-identification. Am I summarizing that correct? Go
That's
ahead.
right. Yes, absolutely.
Okay, well, thank you. And Pam, let's turn it to you to build upon or have your own like additional comments with respect to the two questions of are are these regs even necessary? And even if they're not necessary, what are the beneficial aspects that you see of having regulations relating to anonymization process?
Thanks, Adam. I I'm not sure that they are necessary. I mean, I don't think that they are. I think you could just go with the best practices reference and Khaled very eloquently kind of laid out a lot of the really good best practices that exist today, and that could be all that's required, and it would be a very fulsome law. But that said, I do believe that consistent with what Khaled said, absolutely believe that good laws and clear regs can be very beneficial. They provide that clarity to organizations as they conduct their business. So, it prevents that reticence risk that we might have if we don't have clarity. And it can also provide confidence to individuals. In this case, what we hope for is the clarity to allow innovation in a privacy respectful manner. And then we hope to generate consumer trust in the digital or data ecosystem. I'm going to ground maybe my comments about why I think this is beneficial in an actual fact situation, and some of the people on this call will be familiar with what happened with TELUS and our Data for Good program, but I'll just kind of briefly go through it to highlight where I think these could be beneficial and why. So about 8 years ago, TELUS began building what we called our Insights platform, and it was designed to generate insights from de-identified network mobility location data. So that's data generated from cell tower pings as devices move about our network. Now, when we use the term de-identified, and when I use it in my remarks today, we intended to convey the idea that it could not reasonably be traced back to an identifiable individual. wasn't personal information. For clarity, maybe under Law 25, that would be considered anonymized data. But I'm just going to continue to say de-identified today because that's the term that we have always used. No longer identifiable to an individual. So we did spend years focused on how to do this in a privacy-preserving way. And we consulted experts on our methodology. And in early 2019, TELUS had a new platform containing de-identified network mobility data that researchers could come onto and look for insights, and it was certified for privacy by design. Immediately following that, the COVID-19 pandemic hit, and we realized that this de-identified data could benefit policymakers, epidemiologists, health researchers, governments, et cetera. We embarked on a pretty robust transparency campaign, talking to regulators, the media, and some privacy advocates to ensure that they understood how this data and the insights could be shared in a privacy-preserving way. And then we launched our Data for Good program, which made this de-identified mobility data available free of charge for government researchers and health authorities working on reducing the impact of COVID-19. And it all worked. The platform worked. Our comms worked. There was no backlash. The program worked. People seemed to understand and appreciate it. We even won privacy awards for it and got some international accolades for the program and its impact. Then again, fast forward to the end of 2021, and the environment had changed significantly. And I think it's important to note how political environments, social environments can actually impact the way we look at these things. And that's, again, another reason why clarity is really important. So at this point, the pandemic had transitioned from a galvanizing to a polarizing issue, and fighting the pandemic not necessarily seen as an all good thing, maybe. Certain media outlets began to put a negative spin on our Data for Good program, as did some politicians. So there was a new level of scrutiny, which was fed by a tremendous amount of misinformation. The Public Health Authority of Canada, many of you will remember, used our platform, and allegations were made that they had been tracking Canadians using mobility data that we had provided. It was usually only implied, but sometimes stated outright that this was personal information. I found it really difficult at that time to have fact-driven discussions in defense of our program, especially about the de-identification. We couldn't anchor our best practices in any clear standard, in regulatory guidance or legislation, so it was hard to give comfort to anyone or to the media. I had to give testimony in front of the Ethics Committee of Parliament, explaining how the Data for Good program was leveraging only strongly de-identified data, not personal information of Canadians. And we were grateful that in the end, the ethics report came out and found that we hadn't done anything wrong. But the overall experience left me acutely aware that using de-identified data requires what I sometimes refer to as a degree of bravery, which it should not. And I think that's what Khaled was also referring to. Then the OPC launched an investigation into PHAC's collection and use of Data for Good. And at its core, their investigation turned on whether the data was in fact de-identified, such that it was no longer personal information, subject to the Privacy Act. So it really did turn on our de-identification methodology. If the data we provided was not personal information, then the Privacy Act would not apply, and it would not be a well-founded complaint to the OPC. So they did find in the end that the complaints under the Privacy Act were not well-founded. That was the OPC's finding. And more specifically, they concluded that this was due to the de-identification of the data and the suite of protections used in this case. I think the OPC decision is really important, and I've said that before because it lays out what we see as best practices for de-identification, a lot of which are very consistent with what Khaled talked about, all of which I think really. There's a lot of detail in that decision, and I really recommend reading it and studying it. But what we see overall is a focus on de-identification technique, how the data is stripped and encrypted or otherwise transformed, appropriate aggregation if that fits, access and release model, and the contractual controls in place. I've often said that the decision makes it less necessary to be brave now when using data. It provides more clarity. And similarly, I find that these new regs under Quebec's law do provide more clarity. And while different terms are used, the concepts are, for the most part, fairly consistent. I try to look at this and say, okay, well, would it have applied? Could we have done what we did under these regs? And I believe that for the most part we could. So Section 4 references the need for expertise. Khaled mentioned that as well. That's consistent with what we did. Section 5 outlines the need to start by removing direct identifiers, as we did. It goes on to talk about how it's necessary to then conduct a preliminary analysis of re-identification risk, taking into consideration what they call, and Khaled mentioned these, individualization, correlation, and inference criteria. So as Khaled mentioned, these aren't clear, and they haven't been made clear in other jurisdictions. Frankly, I just choose to believe that the intention behind them is consistent with the concepts that we are a little bit more familiar with, and consistent with our methodology. I think the idea of not being able to identify an individual within the data set, that just kind of almost goes to the definition of de-identified or anonymized data. The idea that you cannot correlate that data set with another data set, and that you can't make inferences from other data sets about personal information. So I'm just choosing to interpret those as being fairly consistent with what we've already seen as best practices, but I fully agree that that it's proven a little bit problematic. And then finally, in the regs, there's this concept of an overall re-identification risk assessment that uses techniques consistent with, and it quotes, best practices. And I think it's really important to say that, well, having a reg that says consistent with best practices doesn't sound like it's adding a lot of clarity. We had used best practices for our Data for Good program, but it wasn't clear to me that that would help us in front of the Ethics Committee or the OPC, because nowhere was there an indication that that was what made it good enough. Right. We didn't know what good enough was. And so regs like this, if by saying you can do this if you do it in accordance with best practices, I would have so appreciated that clarity at that time, because I didn't have it. And I couldn't say to the Ethics Committee, you can be comfortable that we did the right thing because this is what the law requires of us. And so I think this clarity is really, really important. And then finally, and Kelly touched on this as well, I think the clarity around the final threshold of not zero risk, but very low risk is really helpful. And particularly as it does include some criteria for assessing that risk, I think that would also be done in accordance with best practices. I do say that the comments about the consecutive nature of the analysis set out in the regs is maybe a little bit artificial. The idea of saying you strip it out and then you consider whether or not this, and then you do an analysis of that, and then you apply these controls, and then you do your final analysis. I'm not sure that's actually what happens in real life and in the way it plays out in terms of that consecutive nature of your order of operations. But I think it's consistent in concept with what would be a best practice today. And as I said, I really appreciate that clarity. In fairness, when I look back, I think the members of the Ethics Committee who were expected to assess whether or not following best practices was sufficient were left with kind of little to go on, and it was hard to give them confidence, as I said. And in summary, I think regs like these can help. So that is the good news, Adam. I think that there can be something really beneficial in clarity like this.
Yeah,
that's the good news.
Excellent comments. So just to summarize your comments, not strictly required by the reading of the actual statute, especially with the cross-reference, the inclusion of the reference to best practices, but nevertheless helpful because to the extent that it aligns that the provisions in the draft regs, which we're going to talk to because there's some challenges with some of the detail you highlighted, one like in Section 5, for instance, the order, we had flagged that internally. The order actually often makes no sense. The first thing you would do is conduct the analysis. You wouldn't start the anonymization process. So I understand what you mean artificial, and there's other examples. But conceptually, as long as the regs encapsulate in core elements or base elements of what would be those best or very good practices, then it's beneficial because it anchors, it provides some clarity, and it would rely on organizations like TELUS. Like if you had that, these were there were regs that we were talking about in those ideal form to the Privacy Act, it would have been a completely different experience. Maybe not eliminating it, but it would have been a different experience for TELUS. Am I encapsulating your comments correctly?
Yeah, I think so. Thanks, Adam.
Those were very, very helpful. And Suzanne, Any additional comments?
Sure. Thanks, Adam. Anybody who knows me, I think I would tend to agree with Pam that, not sure regs, technically speaking, are necessary given the clear reference to the generally accepted best practices in Law 25. However, because, I often believe that less is more and provide sufficient flexibility for organizations to tailor to the circumstances. But, maybe just briefly before we sort of move on to some of the challenges in a little bit more detail, but sort of at a high level, some of the positives definitely in this version of the draft regs. Some of this has been mentioned already, but, the standard was 0 risk on re-identification. Now we're not looking for that any longer. Concepts of reasonability have been added. There was something in there before about that biometrics could not be anonymized. That language is not there any longer. They've also removed the prohibition on selling of anonymized data. And then, remove that steps need to be taken to make sure that anonymized data is only used for the original purpose. Kind of went counter to what Law 25 says about anonymizing it for serious and legitimate purposes. And then the last one maybe that I just mentioned here is, there was some language before about having to publish your governance steps on your website. There's no doubt in a world of increased transparency, organizations are doing more and more of that. And I know it's not like we're trying to do that as well, but, you don't want to be putting too much information up on your website that way. So, organizations will definitely, just generally speaking, as part of their openness and transparency obligations under the private sector privacy law, will be doing that. But, that was of some concern. So I'll stop with that.
Yeah,
Adam.
perfect. It segues in even the beginning of your remarks, segue to really is going to be the guts of this conversation, is some of the challenges or concerns with the draft text. So why don't we begin with you, Suzanne, on that? What as you read the proposed text, and separate, of course, from the beneficial aspects of this that you and Pam and Colette have talked about, what are some of the challenges or concerns you have with respect to it?
So I'll really start with one fundamental one, and sort of let others speak to some of the other ones. But fundamentally speaking, I think if you think about the scope, just like with the statute, it needs to be clear what the scope for the regulations refers to. And, I'm going to pick up a little bit on what part of your introduction, Adam, but maybe just outline it a little bit differently so folks can follow. So Law 25 clearly mentions anonymization in regards to really a single place, a single requirement. Rather than destroying personal information after business purposes have been completed, you're allowed to anonymize the information for a serious and legitimate purpose. And, I saw Holly's comment in the chat there about, serious, would be considered and thoughtful and not just sort of willy-nilly, right? So so that's one thing that's been added. The second thing is, Law 25 and in Section 23 is actually reflecting a current practice by many organizations in specific circumstances to use anonymization rather than destruction once those business purposes have been passed, when there's still additional value in the data when it's anonymized. And, that's been going on for a very long time. This is not a new flexibility that's being given to organizations, but rather it's carrying forward, if you like, current practice. And again, we're talking about end of life for purposes that have been identified to individuals. Now, what do? Do you delete it or do you hang on to it? And so now clearly it says you're allowed to hang on to it and anonymize it for serious and legitimate purposes. And you did refer to the regulation making power in Section 90, and yeah, it's clear it is may pass regulations. If they were required, I think it would say must. And sometimes provisions don't come into force until the necessary regulations that accompany them are in force. But they do refer to Section 23, like for purposes of Section 23, any criterion terms applicable to the anonymization of personal information. So again, making sure that those regs point directly to those criteria and terms. And then in the draft regs, section 3 of the draft regs refers to where? Section 23 of Law 25, obviously, right? And so a reasonable read of the draft regulations as they are right now is that they're true to Law 25 and that they're limited to anonymization in the context of Section 23 only. It doesn't mean that if an organization anonymizes data in another context and does it poorly, that they may not still be subject to requirements under the private sector statute. But again, these regs were intended to focus on Section 23 requirements to destroy or anonymize. But we wouldn't be here if there wasn't some uncertainty as to that scope. And it's not just the scope in and of itself that's the problem, but there are, Adam pointed to them, penal provisions related to that scope, right? And so, you know, the fact that there is this uncertainty and some concerns, I'm going to pass it over to Karen maybe to delve into a little bit more detail around why that scope could be problematic in this context, right? And then obviously, you know, you tag on the penal provisions there, and that makes it even more relevant and real for organizations. So I'll stop there and pass it over to you, Karen.
Yeah, I'll turn it to Karen just to highlight one point you were mentioning, but just to put a punctuation on it. This is a statute that is designed to protect personal information. If you've effectively anonymized it, then you would by implication address the privacy risk associated there. Now, again, there's even with that zero risk context. And so this by implication is a provision that speaks to post-anonymization context. So I think your points are critical. It's in the statute now, it's passed, but tying it to Section 23 it's an interesting and a comment we've heard from others, the critical nature of that. But Karen, your comments on Suzanne's points, but also more generally other concerns or challenges you have with the text of the draft regs.
Thank you. Yeah, I just want to layer on and go a little bit deeper into some of the points that Suzanne made. For context, anonymization, as Suzanne said, has always been available as an option, and that is codified, especially in PIPEDA. So when you take a look specifically at Principle 4.5 in PIPEDA, 4.53 says that personal information that is no longer required to fulfill the identified purposes should be destroyed, erased, or made anonymous. And it also goes on to say organizations shall develop guidelines and implement procedures to govern this. And so, you know, to me, that's very similar to what Quebec codified. And again, at the beginning of this session, when Adam looked at Law 25 directly, the requirement for this regulation came from Section 23. That again talks about when purposes for which the PI was collected are achieved, that the organization should then either delete or alternatively can anonymize the data for serious and legitimate purposes. So unfortunately, the serious and legitimate purpose requirement is baked into the law. So that's where that comes from. But to Suzanne's point, the entire basis for a regulation comes out of Section 23. And then if you think about maybe why that is, you know, arguably when you're in this scenario, you have finished using the data for your original purpose. Your consent to use that data has ended. either the client has left or the specified purpose that they gave the consent for has come to an end. And so, you're just outside of the permissible uses under the consent regime that you originally had. So when you're faced with that end of life moment, that is where you really should destroy the data. Or as Suzanne said, there's a lot of value in the data that has nothing to do with the PI, or alternatively, sometimes it's just difficult to actually physically destroy data, and it is just easier to anonymize it as just a methodology. And so for that purpose, I guess they say you can destroy it or anonymize it for a legitimate purpose. So in other words, if you're going to choose the route of anonymization, there needs to be, I guess, a reason why, and that reason needs to be legitimate. I'm just trying to understand why that's there. That's, I guess, my theory, working theory. But then, and then when you go to Section 90 that speaks to the regs are tied again for the purposes of Section 23. So I think what the regs are lacking, but what is imperative, is that these regs should really only apply to anonymization when anonymization is being used at the end of life of the data. There are lots of other examples where organizations have lawful bases for creating anonymized data outside of an alternative to a destruction. It could be a method of safeguarding. It could be a method of using it for analysis or modeling. Or maybe to Pam's point, as part of a data for social good, which also is reflected in the new CPPA provisions that talks about de-identifying data in the context of sharing that data externally to your organization for a socially beneficial purpose. And even in the Quebec Law 25 in Section 12, there's a Section 12 that has a consent exception for using data for study or research or to produce statistics if that data is de-identified. So as I'm trying to say, there are lots of bases where you'd want to use anonymized data outside of an alternative to destruction. And why is this important? Some of the provisions of this regulation are quite onerous and wouldn't equally apply to those other scenarios, nor should they. In that Section 12 example for, study, research, or producing statistics, it strictly, it uses the term de-identified, which is something that TELUS was also using, which might be a slightly lower threshold than anonymization, but perhaps not. That ISO standard that Khaled was referring to out of Europe, I think it's out of Europe, that standard also refers to de-identified information, but I believe it's clearly talking about something more akin to anonymized. And maybe that's just a term of art because of the zero risk possibility, that it's nearly impossible to get to zero risk, and so it's difficult to call something anonymized. So I really struggle with a lack of clear application to this regulation and a potential suggestion that it would apply across the board to any scenario of anonymization. And then also separately from that, the concept of anonymization transforms the data in a way that makes it no longer PI. Once that data is no longer PI, there is no basis in Law 25, PIPEDA, or any other personal information protection law to regulate that data that is no longer personal information. And that's gone to court before. There's the Gordon case. There's lots of cases that have gone to court to say this information is outside of the scope of privacy laws. And why that's problematic is that there are certain sections of the draft regulation that almost purport to regulate the data once it's already been anonymized. So by way of example, I believe Section 23, Section 3, yeah, there it is. There's two parts to Section 3. So the first part says that, before you begin the process of anonymization, you have to establish the purpose, which I think just ties back to the wording of the Act that says you can choose to anonymize it as an alternative to destruction if there's a serious purpose for that, a serious legitimate purpose. Okay, so we're going to choose to anonymize it and we're going to have a serious legitimate purpose. Perhaps there's great value in the data with no risk to the individual that can be used for some form of, let's say, a credit model or something that can help prevent fraud, or there's a serious need to keep the data and just strip it in a way that reduces the very likelihood of it being re-identified. But then the second half of section 3 goes on to say, but then if you want to use that data for another purpose, you have to go back and make sure that this new purpose is consistent. But I find this whole paragraph to be slightly problematic because arguably the data is now anonymized and, has met the requirements in section 7, where we've done the analysis to ensure that we've taken into consideration the 5 elements to ensure that the re-identification risk is very low. So if the data is already anonymized, it's outside of the scope of the act. So if we've all of a sudden determined another purpose, why do we need to go back and make sure that purpose is consistent? I'm not sure what the regulatory intent here. I understand the initial purpose. You need to have a valid purpose, otherwise you should just destroy it. That was baked into the law. The information is now anonymized. It's a bit confusing. Now that it's anonymized, why do we need another valid purpose to use it? The data, if you think about the TELUS example, if they've put it on the platform, different researchers that are coming in that have already, passed the legitimate test, they're in healthcare, the data is anonymized. Does every specific use case need to be vetted? I mean, maybe, but to me, I'm just not sure what the basis for that is because we're outside of the scope of privacy laws. So there might be ethical considerations, and I'm not denying that. I just don't think that it should be grounded in a regulation associated with privacy laws. So I'm really struggling with that. I'm also struggling with section 8 in the regulation that talks about a regular reassessment of the information that's out there to make sure that it remains anonymous. So again, once the information has been anonymized, you're outside of the scope of the act. So it's difficult to fathom how this applies. And I don't dispute the fact that there might be a technological advance that might render anonymization technique no longer valid. And I think that that's a real concern. But you can't judge us on 2020 hindsight. You can't say, well, today the information that you anonymized 10, 15, 20 years ago is no longer anonymous and poses a risk. But that might actually be true. But that information, if it's been disseminated or has left the control of the organization, the reality is there's very little that can be done now. If the information remains in the organization's control, or perhaps if the organization is embarking on a new set of data that they intend to anonymize, they can't use an old technique that is now no longer considered best practice. And I feel like it would be caught in that regard, that when you start on a new journey of anonymization, you'd have to use then current best practice standards. And so perhaps what you did 10 years ago is no longer sufficient. But to suggest that you need to go back, and there's no end game in sight, to go back to look at data you might have anonymized 10, 15, 20 years ago to continuously, regularly assess it to ensure that it remains anonymous when you might have lost control of that information. I think Section 8 could be cleaned up a little. It's drafted in a way that's inoperable, ambiguous, and potentially out of scope of out of the law. So again, I just think there are scenarios where Section 8 wouldn't be able to work. And again, those are the scenarios where the information is perhaps in the public domain or it's been there for many years. Perhaps there's some tweaking we could do. I'm not saying it's should be wholly struck out. The whole reg should be struck out, but there's definitely room for improvement. So before we go down that path of the discussion, I did want to say, my main concern is the scope of the regulation and some of the sections of the regulation that are purporting to apply to information that should now technically be out of scope of the Act. So I'll pause there, Adam, just to see if there's more that needs to be added.
Excellent comments, and they align and dive deeper into comments we've heard from clients and other stakeholders. Khaled, you've listened to the conversation thus far. You also raised a couple of concerns and challenges in your initial comments. Can you share with us your perspective on some of the challenges or concerns with the draft regs?
Yes, thanks, Adam. So, as I mentioned before, there are a number of things that are difficult to interpret in the current drafting. So as I mentioned, the correlation, inference, and individualization criteria are have been difficult to operationalize the way they're defined. If you narrow the definition and read into them a narrow scope, then they're workable, but not everybody has read into those criteria, at least the ones from the Article 29 Working Party kind of original document. Not everyone has read into them a narrow scope. So those have been confusing in practice, and including them just perpetuates that confusion, I think, unless, like I said, you deliberately narrow the scope in your reading of them. And then the two things that would be helpful to include are this anticipated recipient and consent for anonymization. But there are two other points which I think would be really helpful, and that kind of came out in the discussions we've had so far. One is to make a distinction between public and non-public data sharing or data releases or data disclosures. If an organization is sharing data publicly where they really can't control and have no oversight on who has the data and what they do with it, that there's a set of risks there and a set of techniques that can be used to manage those risks. And then if you are sharing data with known entities, with business partners, with consultants, with researchers, etc., so that's a non-public data disclosure. There's a whole set of other ways to manage that risk, and the methods you would use are not the same. So that the idea of having additional controls, security controls, privacy controls, etc., you can't really do that in a public data release. With a public data release, you put the data out there and it's gone, and you can't control who gets it and what they do with it. So the whole idea of open data, open science, etc., that is different, and the way you manage the risk there is different than if you are sharing data with a partner where you have a contract and you can impose controls and monitor and so on. So when you think about anonymization, you have to make it's helpful to make a distinction between those two. Sometimes not making that distinction can make it unclear what to do, what the practice should be. And then the other thing that would be helpful to make a distinction about is static versus dynamic data releases. So if you have a static data set, you disclose it once, goes online, it's public, or you share it and it's non-public. That's a different scenario and a different set of concerns than if it's dynamic. If data is continuously being updated and potentially every update is being shared with different group of entities, different recipients, the process you would manage, you put in place to manage that risk would also be different than for static data. So if we want to have regs that define guardrails in a way that ensures that they're applied consistently, then adding those clarifications would be helpful. Now, adding all these clarifications means that we're going to get a more complicated set of regulations with more detail in them and so on, which goes back to the earlier point is, well, if you're going to go into that much detail, why don't you just refer to best practices? But if you're going to write the regs, then it's helpful to put these guardrails in place and make those distinctions so that it's clear to the stakeholders what has to be done and what are the practices that are expected. So if there's an audit or investigation, it's known what the criteria for evaluation or criteria that will be used are going to be. So those are the two additional things I will add: public, non-public, and static versus dynamic distinctions.
All right, thank you. Pam, you as well mentioned in your earlier remarks some of at least a couple of the challenges or concerns, but can you share with us comments you have about what others have said, but any additional concerns that you may have about this?
Yeah, thanks, Adam. So I think that what Kella just said, those two additions are so important because I think that like that level of nuance or granularity needs to be there if we're going to have rules like this, because right now, as Karen put it, these are inoperable. And I think, what happens is the rules have been made with a specific paradigm in mind, like either the static data set or the dynamic data set, or the public release or a private release, and we haven't acknowledged the distinctions that are really important. And I just want to go back to the other thing that concerns me greatly, is this concept of, to Karen's point, trying to govern data that is anonymized and is no longer personal information. And I think, again, if we were to try to do that, which in the context of a piece of privacy legislation is inapplicable. But even so, it's incredibly challenging to start to say that rules can apply to anonymized data and things like having a register. Because I think when we get into the concept of taking what was originally personal information and then saying it's now anonymized, it can apply to a massive range of things, including, and I've said this before, for example, a hospital releasing saying, well, there are 400 cases of COVID today. That came from personal information, individuals with their personal health information that have been counted up and aggregated. That's a form of anonymization. That was personal information that has now been stripped of the identifiers and stripped of all of those aspects that make it traceable back to an individual, and is a statistic that is super useful. So does that now have to be governed under this legislation? Do they have to have a register? Do they have to go back and revisit that statistic at some regular period in the future? Do they have to document what the purpose is for it? If they're going to use it, next month to figure out how much they're going to spend on hospital beds, does that have to have been implied in the original purpose for which they, anonymized it when they were first releasing it to just tell people how many people have COVID? Like these are clearly kind of not the intention that anyone had when they developed the regs. But if we don't distinguish between full-on data sets, which I think is the paradigm they have in their mind when they made the regs, versus other forms, pieces of data that we anonymize in other circumstances, then again, it becomes quite unworkable. So that worries me greatly.
Pam, for folks on the call, what you're referring to is on the screen, Section 9, in particular, Sub 2, that once you've anonymized PI, you got to have a register. And what you're referring to is the statement that register has to be the purposes for which the body intends to use the anonymized personal information. You're giving a couple of just one of what would be an infinite number of use cases where that would be an administrative burden that is just certainly new, like novel, but and otherwise might be extremely difficult, if not impossible, to actually adhere to. I don't want to put words in your mouth, but is that in essence the key point there?
It is. And I think it's not just Section 9, it would also be Section 8, which is the regularly reassess. I mean, it clearly would be, quite frankly, kind of asinine to have to go back and say, I got to reassess whether or not when I said those 400 people today have COVID, whether or not that's now, has to be treated differently. Okay, do I have to record that and document every time I've given out a statistic that came originally from personal information? Like it's clearly not what anyone intends, but that's what the words could be interpreted to say. And we just need to be, if we're going to make specific, explicit rules like this that create administrative burden, then we need to be really explicit about the level of nuance and granularity about what exactly we're talking about.
Those great comments. Let's go, and you've alluded to this already with your comments, and I want to just turn to Khaled for our third question just before we open it up for comments. Khaled, you started by saying that making a couple of suggestions. You've mentioned the challenges with the correlation, individualization, and inference criteria. I don't want to put words in your mouth, but it seems that you're thinking those either have to be aligned, if not struck, because they might not be necessary. You spoke about the need to make a clear distinction between public disclosures, and we'll call it non-public disclosures, and the critical nature of making a distinction between static and dynamic data releases. And if I'm getting this correct, that by dynamic, you mean data that's continuously updated or sent to different recipients, or a combination of that. First, I just want to clarify. Am I accurately summarizing some of the suggestions you have? And separately, would you have additional changes or amendments that you would recommend, given the discussion that you've heard?
I mean, I think the discussion we had around defining the purpose for using or processing anonymized data and updating that purpose over time. I mean, that's a number of questions have been raised about that. I think that needs additional consideration. And then the whole point of reanalysis over time. So, I mean, current practice for static data is and this is for non-public static data. You share a data set, and then the risk assessment to claim that the risk is very small or very low has a time limit on it, either 2 years, 3 years, so that can be determined. And if anything, any of the assumptions that went into that analysis have changed during that period, then you would redo the analysis to see if it changes the conclusion, or if nothing has changed, then after the period has expired, you would revisit the assumptions to see if the conclusion needs to be changed, that the risk is very small. So that's the current practice, and because you're not really redoing the analysis every time, you're just retesting the assumptions. And if you have many data sets, the assumptions are probably going to be the same across many of your data sets. But if you have a dynamic data set, oh, sorry, I think
You just went on mute for 2 seconds, so you didn't.
Okay. So my hand was moving. I must have pressed something by accident. In a dynamic context, this process may be harder to operationalize, and you'd need a more efficient way of thinking about it. So I think the idea of a reanalysis needs further consideration and maybe more nuance to make it operational, to get it to work in practice. So those would be the two other things that I think need to be looked at further from an operational perspective, to see whether any additional nuances needed to make them more scalable in practice.
Nicolette, just so we're keeping track, one is like a refinement to at minimum, a refinement to the reference to like the continual reassessment, right?
Right. That's section 8. Yeah.
Assessment in section 8. And then what was the first, just as a high level, just as we keep a.
And then section 3, you establish the purposes for which that it intends to use the anonymized personal information. If the purpose is changed, must be consistent with section 23 and section 73. Right. Which implies if the purpose is changed, you have to perform a re-examination, which, as we discussed before, that essentially is regulating the anonymized data, and that raises a whole set of other issues.
Perfect. Karen, if you had to make 2 or 3 changes, what would you recommend of the revisions to the draft regs?
Okay, I would ideally remove the entire second paragraph of Article 3, or alternatively just ensure that, if you want to use the anonymized data for a new purpose, just consider whether there's any material change to that circumstance, and whether or not that impacts the anonymization as opposed to the purpose that you're trying to use it. Like maybe this new purpose somehow, if you're, mirroring a data set with another data set, like maybe the anonymization risk is different. So maybe just assess the risk of anonymization to make sure that the data is still anonymized, focus less on the new purpose itself. So Article 3, Article 8, Khaled was talking about maybe limiting the time frame. I also think it should be limited to information that's still under the control of the organization. And it should be, periodically and somehow connected to material events, as opposed to just a routine regular assessment. I'm also struggling with Article 4, the anonymization expert. I understand that TELUS consulted several. Sometimes organizations, especially smaller ones, so less telcos and banks, but smaller organizations might not have like a designated expert, and maybe just relying on best practices would be sufficient, or vetting those practices. So I think that some smaller organizations might struggle with the requirement of having a dedicated supervised person. So I see Khaled's hands up, but perhaps there's another alternative to housing an individual in your organization that can do this. So go ahead, Khaled.
Sorry. I just want to present a counterpoint to that last one. I've seen a lot of organizations that try to do this without the expertise, and it's a very risky thing. If you don't have the expertise, you shouldn't be doing this, because chances are you're not going to do a good job. So, and I've seen that many times where we come in and try to rescue someone who has implemented anonymization practices, and something happened and they have to fix it. So I think that's a really good, that's in the US HIPAA, and I think it's a really good requirement because it ensures a certain level of good practices are always implemented. I know it's hard for small organizations, but
I guess this is where they can hire a consultant versus like they can bring someone in for a moment in time as opposed to putting someone on the payroll. I think some organizations might struggle with this requirement if it was someone that had to be a part of the organization. And then finally, my big overarching comment is that the entire set of regs needs to have a preamble that limits the scope of the application of this section to anonymization under Section 23 as an alternative to destruction, as opposed to having just broad application.
Thank you. Pam, your suggestions.
Well, I've already mentioned a couple that I think in terms of adding nuance if we're going to leave it the way it is. But I think, there've been a few comments back and forth around if we're going to, I think Khaled said if we're going to have this in here, then we need to, get the details and the nuance correct. And I think it might be better to just go with best practices when we're talking about these things. Also agree with all of the things that Karen just said, but I think if we just went to best practices and rather than trying to get specific and prescriptive, because I do worry that we're going to go down a rabbit hole of needing to have a tremendous amount of detail, and that gets worrisome. So I think it's a bit of an atomism, but less is more here. And if we can stick with best practices, then that can shift over time in the same way that we have, historically done that in the security context. Security standards, what's acceptable from a security standard is different today than it was 3 years ago, even a year ago. We need to be able to stay up to date on, what is a best practice. And the more that we write in here, the more confusing it might be, and the more likely we are to end up with a regulation that is actually self-defeating. So I think if we can be, I think the clarity is still there if we talk about best practices, and increasingly we have more best practices. We've got findings and decisions. We've got ISO standards. We've got more and more experts out there. But I think if we've got the clarity that that's the standard that's required in whatever the circumstances are, then I think that's sufficient and probably safer, and will result in a better, more effective law that will protect privacy.
Great comments. And last but definitely not least, Suzanne, recommendations, if any, supplemental to the ones you've heard, or anything you want to just reiterate.
Yeah, so maybe just a few, and I said it at the top of my comments too, less is more, because we need to avoid being too prescriptive, or else we will fall prey to having regulations that will quickly fall behind. And so, we don't want to do anything in these regulations that chips away at the importance of generally accepted best practices. Like that needs to be, to go through the regs with a fine-tooth comb to make sure, is there anything in here that would take away from an organization following generally accepted best practices. And like some people look at generally accepted best practices and say, well, those are subjective. They are and they aren't. Courts hold organizations to generally accepted best practices for your industry all the time. So this is not really a new concept. They're always relevant when it comes to the type of industry, the sensitivity of your data. We talked about internal and external use. So anything that chips away at generally accepted best practices, I think should be removed or adjusted. Resist attempts to repeat what we find in the law and the regs, unless it's there to reinforce the importance of generally accepted best practices. Avoiding language like a register. We updated the private sector law to get rid of some of that non-technology neutral, narrower type view of how maybe a business is run. So we should avoid language like that. And then maybe the last one, and this goes to some of what Khaled had mentioned before too, is we should avoid the combination of words that create confusion. So if you take the example of no longer requiring zero risk, well, then don't put irreversible at the front end of that paragraph or sentence. Sort of the same thing, if you're going to require generally accepted best practices, don't throw something in there that causes confusion. And so I think being really sort of cognizant of that would go a long way. And with that, I'll stop.
Yeah, the great comments. Just before we turn to the floor, the one thing, and I think it came up implicit in some of the comments, but just go to section 3. Well, first, let's go to the regulation, Catherine, the regulation authority in section just above. The regulations are determining the criteria and applicable to the anonymization. This is the process, one would think, from the wording of that. Go to section 3 in the regs. One recommendation, I think this picks up and builds upon Karen's comment, just remove section 3 altogether. That's not about the process for anonymization. That's about this purposes aspect, which, as we've talked about, and there was a number of excellent comments, is just challenging. Why do you even need that? This is about the process. Perhaps this is even ultra virus the regulation authority, but that would be the case. And then flip to section 9, and I want to pick up, Suzanne, on your points, and then it was emphasized in particular by Pam. Let's not use the word register, but is really any of this section 9 necessary? If you're going to do an appropriate assessment, there'll be documentation in respect of that. Why do you need this register? Especially number 2, which is the one that Pam very eloquently cited all sorts of challenges with. So we're hopeful, and I think you're hearing across the board, and I think this is a comment we've gotten from a lot of folks, that less is more. Don't make this unnecessarily complicated. This is an incredibly nuanced area that start with Colette, a globally recognized expert. It could speak volumes about how nuanced this gets. Less is more. That will serve a lot of the benefits that folks have talked about, but at the same time not create these operational challenges and arguably overreach in terms, at least vis-a-vis the public policy purpose of what the statute is generally, as you mentioned a couple of times, Suzanne and others, as well as what these regs really need to do, which is just give some baseline on what is simple elements of the best practices for the anonymization process, aligned with what's already been out there, and in many cases have been done for a while. So I think at this point, those were excellent comments from folks on the panel. Let's open it up for comments. We're very interested in your comments on what you've heard, or certainly questions for the panel, who are just each of whom are tremendous experts in this area, and one or more of them may be able to respond to a particular question. There's options. We really welcome folks to raise their hand, give some verbal comments. If you're so inclined, that would be really, really helpful. And secondly, it would be otherwise helpful just if you put in comments. I know there's a number of comments already. I see close to 60 comments in the chat. and we could, through Caitlin, who's moderating those, can share those comments and we can comment on those and any questions. So I'll just turn it over to you, Caitlin, to moderate the next part. And Catherine, let's just leave this up on the screen because certain of the comments might focus on provisions and we can have that in front of us for the discussion. So Caitlin, over to you. I don't know if anyone's hands up for a comment.
We do have a hand up if you'd like to start us off.
Thank you for that. I mean, you were picking up on several themes. First, less is more at minimum, if I'm hearing you correct. Secondly, if you go to, let's go to the register. And this to your point, I can tell you that in terms of comments we received at the firm, and this is from clients, but also just with stakeholders, this is one that was problematic and perplexing operationally for many folks. The word register was a little bit of a mini lightning rod. Like, what do you mean a register? It seems a little bit dated, but as you mentioned, when you do a PIA, you'll document the relevant things in there. Why do you need another administrative requirement separate and apart from those documents which are relevant? It's a great point, and I don't think it's a small point. I think it's very significant. Every single provision, I think you eloquently set it out. We're recommending, and again, the recording of this is going to the Quebec government. We're recommending stick only with the bare minimum of which required to provide the clarification that would be helpful, as Pam very eloquently said. Everything else is going to risk adding complexity, administrative burden, and otherwise highlight the novelty or distinctiveness of Law 25 or the amendments brought in by Law 25 from many other statutory regimes. So I think your points are just dead on and really picking up thematically on the comments we've received. Any others want to comment? I think that's a valid implied assent to the value of your comments. Are there anyone else has put their hands up?
We did receive a question before the session, Adam, and I think it will help ground the comments as well in practical examples, just like Pam had given, rather than keeping it esoteric as one of your favorite words. What are the real pragmatic use cases of anonymization for organizations, except as an alternative method to destruction, especially for the financial sector? In other words, does truly anonymized data retain any value for an organization? And if so, in which context, for what types of use cases?
Yeah, I mean, we have great panel on this. I mean, maybe we take it out. It's not really just banking, it's anything. Pam, maybe you can just build upon your point that you made about those use cases. You gave a couple, but certainly our clients across the board, there would be an infinite number of use cases where every day they're using data that is in anonymous form to achieve a myriad of business purposes that by implication wouldn't have any privacy issue because the data has been anonymized. But Pam, I'll turn to you because you could speak from organizationally perspective, and then the other panelists can weigh in.
Yeah, absolutely. Honestly, it's the sky's the limit, as you say, an infinite number. So, in the context of the data for good that I referred to with de-identified mobility data, we were able to see large scale movement patterns. For example, during COVID, we were able to see were people responding to different policy decisions that were made. So when the government came out and said, please don't go to your cottage this weekend, did people listen? When other jurisdictions came out with, we could see, did people go to their cottage that weekend? Did the emotional plea work? We could compare that to other jurisdictions where they may have made an absolute rule. Did that impact people differently? Was it more effective, less effective? So, large scale patterns. But that's true in every possible area of a business or in trying to solve social problems. Health data, absolutely, like de-identified health data to understand are people who are going to their doctors and getting prescriptions and filling those prescriptions getting better at a faster rate? Like, these are big picture answers to questions. And when we're looking for patterns and trends, which is so much of what we are always looking for, we don't need identifiable data. De-identified data will do the trick. Absolutely, when we look at things like AI and the power of AI, which I don't think anyone is questioning these days, it comes from the power of being able to look at trends and patterns. And you don't need identifiable data to create those trends and patterns. So, all of the things that you can do with AI, we can use de-identified data to do, or almost all of them. But every day in the business, in terms of, how many people who use this product would like that product, this can be done with de-identified data. So it's really, really the sky's the limit, and there's so many more opportunities. I think businesses are often missing an opportunity to use de-identified data in certain circumstances where they could be doing so, and they're using personal information instead, or they're simply not going through this process and are missing out on those big picture trends. But at a government level, social level, health for sure, and business level, there are just endless opportunities to use it, I think.
Yeah, and as you're talking, I was just thinking, like, and for years this has been done with actually 99.9999% of the time zero issue. Anonymized data used for business strategy, anonymized data used for improving products and services, or most critically, the innovation that you're speaking about, AI just being the latest part of those innovative efforts. So huge things, which is why a set of rules that applies to anonymized data is inadvertently, and has, in my view of this, and we've heard this from other folks, unintended consequences of this. So this seemingly small on a requirement, just create a register and keep track of all these purposes. The burden on that, especially for larger organizations, would be beyond immense. And frankly, Section 9, again, as we mentioned before, is it even necessary? Which leads to that. And really, what value does it bring? I think it's a great point for each of these provisions to be highlighting. Caitlin, any other hands up for comments?
Rosario has just put her hand up, so I'll unmute you.
Great.
Hi there. Just wanted to echo, Adam, what you just said about the burden on smaller organizations, or organizations perhaps that have a high volume of work. And that's certainly the case in the healthcare industry, as Pam mentioned, where you have constant reporting and dashboards for evidence-based decision-making. So dashboards are used by Toronto Public Health or public health units. They're used by the government at the ministry level. How many, homeless shelters do we need to open up? What do we need to do about this? I mean, every single decision-making that one would hope that is made by the government is based on data. And internally, certainly, decisions are made using data that has been de-identified for whatever purposes, or even included on websites. And even, those individuals that conduct, at least at the organization where I work, they do projects, and then those get reported in presentations and in journals and manuscripts and lectures and a number of different dashboards. I mean, it's just astronomical when you think about the number of instances, once the data has been de-identified, that it then gets leveraged and used for accurate decision making. So it does seem unwieldy to me to have that Section 9 in there. So just a comment on my end, Adam.
Well, that's great, because you're looking at it, and I think it's a very helpful prism to look at these things. What's the value, keeping in mind not just the specific words, it would be good to have these things, but even given the burden that would be placed. And we've had discussions in a number of different contexts that there is a freight train of regulatory burden coming down nationally Law 25 in particular, but nationally, on companies across the board. And it's imperative, our view from a public policy perspective, that governmental authorities who are creating these instruments really bear down and include what is going to be helpful, aligning for the overall purpose consistent with the spirit and intent of the Act, and just absolutely remove any unnecessary administrative element that's not going to serve a valuable purpose. And we've had a number of comments, and eloquently supplemented by yourself, Rosario, that highlights like Section 9, the suggestion, well, why require it? Doesn't seem necessary at all. Anybody else have their hand up? Caitlin?
Khaled does.
Oh, great.
I just have a comment in defense of Section 9. Is that
Well,
one?
as you comment, I just have a question for you. Assuming, and you might be getting to this, but assuming you have performed an appropriately, that would be tailored for the circumstance, appropriately rigorous assessment, risk re-identification, etc., and you've documented that, and it's there. What is the value of Section 9? That would be really helpful to hear.
Well, it's to make sure that it's documented, because when things go wrong, the first thing you bring out is the documentation, and it may happen 2, 3 years, 5 years after the fact. And having that clear documentation, it will be very important in those cases if there's an investigation or an audit of some sort. And the question I get asked often is, what should be in that documentation? Give me the table of contents so that I can make sure that I cover everything that needs to be covered. So in that sense, Section 9 is helpful because it gives you a little bit of that table of contents. But I think the documentation is important. I don't think it's complete, but it's a start. It covers some of the important things. But nevertheless, having the documentation is important, because when things go wrong, you will rely on that documentation to explain what you did, the rationale for the decisions, and the steps that were the process that was followed, etc.
Right. So go to Section 5. I think we should bear down on this, because I think there would be alignment that when you, first of all, best practice, not even best, but a standard practice, that you conduct an appropriate analysis of the re-identification risk. And when you do that analysis, Colette, I'm assuming the organization will document and keep relevant documentation in connection with that. If you have it there, if you have the documentation, no one's doubting the value of documentation, why would you need a separate register? Or is your point, it's not necessarily the register, it's the documentation?
It's the documentation. You need to put it somewhere. It's important. If you can make it explicit, that's better, just to make sure it gets done. But removing a documentation requirement completely, I think, will result in lack of documentation, which can be problematic in practice.
Yeah, because the comments we've heard, and go back to Section 9, Catherine, with respect to this, is number one, and I like the comment today, like this register term itself seems a little bit dated, but that's the most minor of points. The number two is problematic because we've talked for all sorts of different reasons. And then the comment that I've received, we've discussed offline with several clients and other stakeholders, is why do you even need this if there's appropriate documentation in connection with the risk assessment? And look, you do a PIA, you have documentation. You don't need a separate register to deal with it thereafter. So I think there's alignment and common ground. It's the documentation piece. Let's not have any extra burden. Is that fair?
Yes. Yeah, that's fair.
Are there other questions or comments? Just mindful of time.
Adam,
Yes.
Adam, I was just going to add one little teeny piece to that, and that's, I don't think it's the documentation that's the issue, and I think you've highlighted that. I think it's the scope of what is being documented, and I really, actually, I saw in the chat, Rhonda Wing has put a great comment in there about how important it is to stress test Section 9 with real life scenarios, and to understand what she says, and to understand what a hurdle it risks constituting to essential decision making and information dissemination. So again, back to well, there are 400 beds filled with COVID patients. Does that have to be documented? Because that was a stat that was derived originally from personal information. Like that clearly can't be what is contemplated here, but it's not excluded. So that I think that's my concern with Section 9 is the scope of its application more so than the concept of documentation. Like, I mean, I'm all for documentation. We documented everything we do, and we do big, important de-identifications.
I think that's a great point to like punctuate. It's the scope issue. And then especially with 2 and 1, but 3 and 4 and 5 would seem to be replication of what you would have otherwise typically done. And certainly all of them, each of these elements should, if you're going to even keep Section 9, needs to be carefully viewed with very practical. And I think Rhonda's point is excellent. So there's a comment here. Section 9 is in order. Can you read that? Because I think I want to make sure there's common ground. I think there is. The latest comment, Caitlin, could you read that?
Sure. In my opinion, Section 9 is in order. Privacy legislation is big on transparency. I understand that a PIA would likely have been completed before the latter anonymization. However, the anonymization increases the use of this information, which, by the way, is no longer personal information, but was derived from personal information, which is a point that Pam has made. In my opinion, it provides individuals the ability to provide an informed consent when initially providing their personal information.
Right. I think that point, which I understand, I think is really important. And several of the panelists mentioned this, and it's critical. The legislation applies to the protection of personal information, the collection, use, and disclosure of personal information. This legislative scheme, the proposed legislative scheme that's replacing PPIDA, CPPA, other legislative schemes globally, have a scope limitation where the data is personal information, and therefore there's a privacy interest, of course, that would vary with the sensitivity of the data. Once the data is effectively anonymized, you've effectively addressed that privacy interest. At least that would be the starting proposition. And what Section 9 goes to is not necessarily transparency. It goes to an internal, because this registers is just to be an internal document. It sets out 5 things that at least several elements of which would be already documented in the context of performing just the risk assessment, which would be consistent with best practice. In other words, aspects of this register, if you remove 9, but following best practice, there would be adherence to certain aspects of this. But critically, there's a couple of aspects of this that at least clients are telling us, and you're hearing on this call, it would be potentially, at minimum, hugely challenging, if not almost practically not feasible, to keep track of purposes of non-identifiable data doing it, and for all the reasons that are there. So I think there's common ground, but I wanted to highlight my reading of this. This isn't a transparency piece. This is read as a supplemental administrative obligation on organizations to create a register distinct from the assessment that would typically contain the relevant aspects of this. I'm interested in other panelists' comments on that. Again, I assume, well, let's turn, Caitlin, to, are there any other?
Sorry, Adam, I think I'm just to your point that I would agree. I think I'm struggling with the word register and the prescriptive nature of this requirement. If anything, I would think you could just simplify it to say that organizations have to be able to demonstrate accountability or compliance with this regulation, should they be called upon to do so, or should maintain a record demonstrating their compliance, like something a lot simpler and less prescriptive.
Yeah,
I'm not disputing that we should do what this says and be able to demonstrate our accountability and compliance, but that's what we have to do across the board with all privacy requirements, being able to demonstrate that we've met this requirement and that requirement. So this is the first time that I'm seeing such a prescriptive way of doing that.
Yeah, it's interesting, and it's generating a lot of comment. Your suggestion, Karen, would align with the spirit and intent of, I think it might be, I don't want to put words in folks' mouths because there's folks making comments on this, by dealing with, we'll call it demonstrable accountability, at least vis-a-vis this, at the same time without the prescriptiveness, aspects of which would be almost impossible to implement. We would have score, like I'll just speak, we have scores of clients that would find it exceptionally difficult to adhere, at least to this purposes piece. Like I'm not even sure when we factored this number too, I'm not sure the purpose or the value of it, but even if you were aligned on there, it's just not going to be feasible. Larger enterprises would have like multiple staff doing this. That's all they'd be doing. One would think, to operationalize. Maybe interested in comments on that, but that was our view, and that is the comment. I'm just reflecting multiple comments we've received from clients who've actually looked and meditated on some of these provisions. Any other comments, Caitlin?
Wait,
Yes.
sorry, Adam, just before we leave that, don't forget Section 3 requires that before you anonymize the data, you have to first establish the purpose that you're intending to use it for. So again, as long as you can demonstrate compliance, establishing one purpose, the initial purpose for anonymization, is very different than what's required under Section 2 of Section 9, which is all the purposes that you intend to use it. Really, as long as you've got the one that you initially anonymized it for, you can demonstrate compliance.
Yeah. Yeah. Look, there's great comments we're receiving upon this. It's certainly an interesting discussion. Comments are worthwhile considering. Caitlin, any other comments? I'm just mindful of time. We just have a few minutes. We said 2 hours. We meant this to go about an hour and 45 minutes max.
For sure. So there is a written comment that I would like to get to on Section 8, but just to make sure that I'm not cutting anyone off on their ideas on Section 9, I'll call on David Elder, and then Satinder Ball also has comments.
Great. David, nice to hear from you. Thank you.
David, I've unmuted you. You should be able to make your comments. All right, I'll pass it over to Satinder. David, if you...
Sorry.
Oh, there you go.
There we go.
I'm here. I'm speaking away, and I've got my actual mic on mute as opposed to the Zoom. Sorry about that. I apologize in advance if I missed part of this, so maybe you covered it. But to what extent, legally speaking, do these regulations apply to anonymization done for the purpose of taking a data set outside of the scope of the Act, versus anonymization done as an alternative to destruction following the purposes for use of the personal information being fulfilled? Because as I read it, it's very much Section 23. Section 23 is very much founded on when you get to the end of the life cycle for data, this is the procedure and these are the regulations. So if you do it for some other reason, there's nothing that says you can anonymize and create an anonymized data set and during the currency of the information. But I'm wondering if legally speaking, we think these regs would apply.
David, you've just reiterated comments from several of the panelists about the scope and the necessity to look at these provisions. Can you go to the statutory provisions right at the top? You're highlighting one of the things that has come up several times is these anonymization provisions are set out not generally. They're set out under the destruction provision. When you're finished end of life, as was articulated by a couple of the panelists. So you're just reiterating a view that we've received and we discussed earlier, but also outside the context of this discussion today, a lot of people are expressing as well. It's a scope consideration. So point very well taken.
Sorry for raising it again. Sorry.
No, it's excellent.
It's for emphasis. Yeah.
No, it's not, and it's not. This is a critical point that I think has been raised by a number of stakeholders across different sectors. So thank you for raising it again. It's helpful to reemphasize. There was someone else who had put up their hand.
Yes, Satinder, I'll take you off mute now if you'd like to provide your comments.
Hello, thank you. Good afternoon. I just want to go back to section 9.
Sure.
So the reason we anonymize data in the first place is there has to be a serious and legitimate reason for doing so. Otherwise, we should be destroying it. Now, section 9, excuse me, I believe is asking, what are you anonymizing and why are you anonymizing it? And ensuring that you're using the right best practices for anonymizing it. So I don't have an issue with section 9, so I don't see why the panel has such a concern with it. I think it's a fair question when you're coming to audit and assess how well a company is meeting that part of the law.
So Satinder, first of all, thank you for that comment. I guess the question for you, Karen Grohl had suggested an approach that for the purposes of demonstrable accountability, which is a new theme in multiple different statutory frameworks, necessary for folks to have evidence, organizations to have evidence of compliance. So I think there's common ground there. Assuming that an organization has engaged in the assessment that's expressly contemplated in above sections, number one, and otherwise it is just a core feature of best practices which have to be followed. That's the statutory requirement. Like if you had no regs, you have to follow the best practices. That's basically in there. And that undergoing the relevant, applicable, and appropriately rigorous process of de-identification or anonymization, you would have a documentation of that. So we're aligned on that. If you have that documentation, do you still feel that a separate requirement for in section 9 is still required?
Yes, for accountability to the act. And if you're not accountable, there are significant fines.
Right.
So you could have PII, you could have best practices, but they're outside of the act. And I think this forces companies to comply with the act.
Right. So I just want to make sure, because I want to make sure I'm understanding. So there's common ground, and you have on the panel folks that have spent like an immeasurable amount of time with their accountability frameworks. No one will doubt or shed any type of issue with your point. Like the accountability is critical. It's a fundamental feature of the statutory regime. Assuming that it's an obligation which would by implication occur that, let's say there was an investigation and an organization had the documentation, just forget about section 9 for a moment, had the relevant requisite documentation to show that they've complied with the section 23 requirement, and even complied with the regs above, the provisions above that relate to the assessment. So we're agreeing with everything aspect. They have that documentation for accountability, demonstrable accountability. What is the value then of an additional requirement for a register?
So I think this comes back to specifically the case of anonymization, serious and legitimate. I agree. You're not going to reinvent the wheel of something you already do. So if you have a PIA which meets these requirements in section 9, you're good to go. You're ready. But those who don't need to comply with this and need to have these features in their data practices.
Right, I see. So in other words, you're saying at least elements of section 9, because there's a second level to this. You're saying as long as folks have that for accountability, you would satisfy 9 or otherwise. I mean, I think the comments we're getting is that this is already two aspects. One, you're already satisfying when you conduct the assessment, because that would be the case. You would be documenting that. You're saying clarify that. That's number one. And the second point, which I think is a point that certainly, as I've mentioned a couple of times, we've received from a number of clients, and you got this on the call from the panelists as well. There's aspects of section 9 that are prescriptive beyond what is perhaps even practical or even feasible, and perhaps even unnecessary for the purposes of what you're referring to.
I agree, Adam, and I did have some conversation with Pam on this. I think it's also an interpretation. So Pam's interpretation of Section 9 was different to mine. So Pam had said, well, this was also for grouping of data, etc. My interpretation of this is for an instance of a specific individual's data that has been anonymized. So Adam, your data has been anonymized. What's it been used for? But once you group data from several individuals into another setting, then is that really at a PI level? So I think someone else put a comment that this would be something that would be taken to the courts. But but just the Section 9, I know there was talk about going back and saying get this removed. I would not be comfortable getting this removed, because for those people who don't have mature PIA practices, this is something they need to be following or implemented.
Got it. Well, like again, these provisions helpful to have these discussions and clarify. It's a comment, and again, this session, just for clarity, is being recorded, and the entire session is being put forward. The recording of it's being put forward to the Quebec government. So your comments will be received by the government officials who are responsible for the draft reg. Okay, thank you for allowing me the time to speak. Thank you for the comment. And Caitlin, just in the interest of time, we have time for one more comment.
Yeah, there's a really great one here. Bear with me. It is a bit lengthy, but it's worthwhile, I promise. And this is related to Section 8. If we take a step back and look at what appears to be an underlying concern that in X years, there would be a new technological advance that would permit someone a higher probability of being able to link between data sets to re-identify someone, would that mean that the data set that had been anonymized in the past may no longer meet the very low risk threshold and therefore would be reconsidered as personal information? Or if the circumstances change such that information that had a very low risk of re-identification when kept internally with safeguards would now be made public, where there are fewer safeguards? In those cases, wouldn't it make more sense to monitor the environment and the circumstances for material changes to re-identification risk instead of requiring organizations to regularly reassess the information itself?
Great comment. Khaled, interested in your comments on this because we've had a lot of conversations about Section 8. Interested in your comment on that thoughtful comment we just heard.
So by analogy, in the security world, we deal with risks in a similar way, in the sense that in the context of encryption, we know when certain key lengths are no longer going to be acceptable. Actually, NIST publishes a schedule that says in X number of years, key lengths have to be increased from X to Y. And at that point in time, you have to use stronger, essentially stronger encryption. And we have a schedule for that. I mean, it's an approximation, but it's a schedule. But it doesn't mean we don't encrypt today, because we know in 5 years that that standard will no longer be acceptable or will no longer be strong enough. We still have to use the best methods and the best technologies available today to protect information, knowing that in X number of years that risk will go up. So we already operate in that environment where technology, we know technology will move forward, and we even have a schedule to tell us when. It's not as uncertain as we're talking about now with anonymization. With respect to what you should do, that's an interesting question. I mean, if you know that the environment has changed, I think that a recommended practice would be to recall the data set if it's possible, because sometimes it's not possible to do that. But if you're sharing data or making data available to a partner, you'd have a provision in your contract saying that if the risk ever changes, we may have to recall the data set and replace it. And you'd have that provision, and you'd recall the data set and replace it, so that you're still sharing data that's deemed to have a very low risk. It's a public release. There's nothing you can do about it. That is always going to be the risk with public releases. And the first case, what does a recall mean? that's a process issue that has to be kind of determined on a case-by-case basis, I think.
Well, on that note, we're just about at time now, and we're going to end the session. First of all, I want to thank you, Khaled, Karen, Pam, and Suzanne for extremely thoughtful comments and the time that each of you put in for the preparation of this. And thank you to Caitlin and Catherine on our Osler team for helping to prepare for the session and moderate today's. And most importantly, thank you very much to everyone who attended. Really appreciate the attendance and a lot of thoughtful comments. Again, this recording is going to be, we're going to process it, and then we're going to send it in on or before February 3rd. And we'll make sure that all attendees, registrants, as I mentioned, there was over 700 registrants for this. All registrants will receive a copy of the recording for your future reference and consideration. So thank you very much, and we'll hope to see everyone soon. Bye-bye.